Hi, welcome to another session. So in this session, we are going to see about the hate speech. So there is a lot of news from the last 1 month about the hate speech in Haridwar and in Delhi. The uh, Hindu Yuva Vani in Delhi and Yati Nursing Anand in Haridwar in December 17th and 18th. So there they started using this hate speech. They called for violence where they called for the violence, calls to violence were made against the Muslims. Okay. Now, in this situation, does the hate speech, that is nothing but dharma sandhan, ethnic cleaning, they called for the ethnic cleaning in the same way like what the Myanmar has done, the Rohingyas, in the case of Rohingyas, they were overthrown. So same way in Uttarakhand also such kind of hate speech against the minority. So there was an articles in the Hindu editorials about the hate speech is the time of in the time of free speeches is the freedom of speech is absolute. Okay, so the rising frequency of hate speech in India has not gone unnoticed. So the Supreme Court has taken that we will hear the petitions of these Uttarakhand hate speeches. Okay, so in this video, we will see what is an hate speech, what Indian Constitution talks about the hate speech. Okay, and also we will see that what are the major reasons for the hate speech and how Indian laws are dealing, IPC and CRPCs are dealing with the hate speech, and what kind of committees which are being formed like TK Vishwanathan committee, and also what is the law commission proposed about the hate speech and what are the cases related with this hate speech. Okay, so let us start this video. So what is an hate speech? Hate speech, see, the black law, so there is no particular definition. Actually, there has neither been defined in the Indian legal framework, nor can it be easily reduced to the standard definition. Okay, neither been defined in the Indian constitution or Indian law, or neither it can be easily, reduced to the standard definition. But Black Law Dictionary, Black Law Dictionary has defined speech that carries in any hate speech, the hate speech, any words written, spoken, or sign visible representations within the hearing or sight of a person with intention to cause fear or alarm or intentment to violence. Or it is defined as the public speech that expresses, it is written, public speech that express hate or encourage violence towards a person or group of person based on something such as race, religion, sex, or sexual orientation. Suppose there are two friends. Okay, one belong to the other caste or race or religion, or other belong to other. If a person says starts speaking, one person, both are friends, if a person starts speaking against the other person's religion, then he is trying to create violence, he's trying to create fear, so which encourages violence or trying to create violence towards a person or a group that is based on the race, religion, sexual orientations, and sex, that is called as a hate speech. Okay, that is called as a hate speech. So what happens, even in the, there was a famous case that is called, the case is called Pravasi Balai Sangatan versus Union of India 2014. So they also describe, see, hate speech are efforts to marginalize individuals based on their membership in a group. Okay, so it is hate speech is an effort to marginalize individual based on their membership in a group, and one that seeks to delegitimize group members in the eyes of the majority, reducing their social standings and acceptance within the society. That is nothing but your hate speech. So what it says in Pravas Ballai Sangatan versus Union of India, that hate speech is an effort to marginalize individual based on their membership in a group, and one that seeks to delegitimize the group members in the eyes of the majority, reducing their social standings and acceptance within the society. Even this talks about the hate speech definition. So they have defined, there is no standard definition for the hate speech in the Indian law. So does the Indian Constitution and hate speech, what does Indian Constitution and hate speech talks? See, we have an article 19. What is this Article 19 clause 1A says? There is a freedom of expression, free speech and expression, right to freedom of speech and expression. There shall be a right to freedom of speech and expression. Now, what does this freedom of speech and expression talks? See, Article 19.1 talks about a freedom of speech and expression. Freedom of speech and expression, right? So in terms of speak, you can speak or not, you can keep quiet also, you can express in terms of words, gestures, media, and also he can speak not only for him, he can speak for others also. But if you look at this, the Ramesh Thapar case, what the Ramesh Thapar case says, see, it has expanded the scope of freedom of speech in 1950. Ramesh Thapar versus Union of the State of Madras. Okay, State of Madras, what it says, the freedom of speech and press is laying the foundations of all democracy. So if this is your democracy, in the democracy, the foundation for the democracy is freedom of speech and expression. Freedom of speech and expression. So this is your democracy. So this is a freedom of speech and expression, Ramesh Thapar says. So without free political discussion, there is no use of public education. So if there is a freedom of speech and expression, without free political discussion, no public education essential for proper functioning or for process of popular government is possible. Okay, this is expanded in Ramesh Thapar case. And also it says that there will be checks on the powers of the government, on the democracy, by using this freedom of speech and expression only. Check powers. It can check the powers. That means, like for example, I can say the civil society, the strengthening of civil society. Yes, it will strengthen the civil society. Like example, I can say about your example, your CAA, NRC, then a repeal of farm laws, etc. Then it brings a transparency also. Example, RTI. It also brings governance. So there can be checks on them. Is it clear? So there can be checks on them. So freedom of speech. But when this freedom of speech and expression, Article 19(1) was brought in the discussion in the making of the Constitution. There was a long debate, and Alladi Krishnaswamy Iyer said that freedom of speech is not an absolute freedom. There is some reasonable restrictions on them. What kind of reasonable restrictions? There is subject to the reasonable restrictions. What? Based on the sovereignty, security, friendly relationship with foreign states and public order, and also the contempt of court, defamation, or intentment of an offense. It is not an absolute. There are certain reasonable restrictions on the freedom of speech. So this is about Indian Constitution, who talks about that regarding Article 19(1), 19(2), Clause 2. Then, what are the major reasons for the freedom of speech? Major reasons for the freedom of speech. See, the first is your sense of superiority. See, what it says, that the sense of, it is one of the major reasons to give the voice for the hate speech. So whenever the person feels that he is superior above the other persons, then he starts dominating the persons. Superiority of oneself over the other person starts dominating the persons or the group, and from there hate speeches come. So superiority, the sense of superiority. Then stubborn. Second is stubborn behavior towards particular ideology. Towards particular ideology. The stubborn behavior. What is this stubborn behavior? See, when a person or a community or a group starts showing their stubborn behavior, they do not listen to what the other persons are saying, their opinions, their thoughts, etc. at that particular time. It led to the spread of the hate speech. And because people are losing their patience, it's a patient particular time, and they are trying to rule over the other persons, that causes the hatred. So stubbornness, stubborn towards the ideology. That means to particular religion, to particular race, to particular group, etc. Okay, so there is a stubborn, right? Clear? So there is a clear-cut stubborn ideology. Okay, so there is a negative stereotype also. The people who are negative stereotypes lead us to think for other individuals as inferior. Stereotypes, negative stereotypes. People are negatively that this is my religion, this is my thing, that are there. So this is a hate speech. This is the reason why this negative stereotypes. So negative stereotypes leads us to think for other individual as the inferior and less worthy. What they think, that this is the race or this is the caste, that they try to over dominate. This is the inferior. That is a stereotype, negative stereotypes. Okay, so these are the major reasons why, major causes. Okay, then what are the laws that are dealing with the hate speeches in India? See, hate speeches, mainly the law is section 153, IPC and CRPC, section 153A. So what this section 153A says, the promotion of enmity. Suppose if you are promoting enmity between the persons or between different groups on the ground of religion, race, place of birth, residence, language, etc., and doing acts prejudicial to maintain of harmony in an offensive punishable with 3 years of imprisonment. So if you are trying to create enmity between the groups based on these things, then doing an act of prejudicial to maintain the harmony, then you will be punished. Section 153, promotion of enmity. This is of enmity between different groups. Okay, different groups. Then section, there is section, one more section, 505. 505. So what this section says, criminalize the publications or circulation of certain statements, rumors, reports, intention of such statement that affect to create mischief or upset the public tranquility. Criminalize the publication. So it criminalized the publications of the statement. The publications or circulations or rumors that upset the tranquility, to create mischief or upset the tranquility. Section 505 says this. Then what is section 290? See, this is 295. It's 295. This is. So what is the section 295 says? See, section 295 says, criminalize the destruction of place of worship or sacred objects. Criminalization of criminalizes the destruction of places of worship or sacred objects. This is one thing. Then also Article 298 criminalize the speech that would hurt the religious sentiments of a person. Criminalize the speech that would hurt religious sentiments. So these are some of the laws that are dealing with the hate speeches in India. What this Election Commission Representation of People's Act says. Section 8 of the Representations of the People Act says 1951 prohibits the person convicted of using free speech illegally from contesting of election. And section 123A and 125 of the Representation of prohibits the promotion of hatred based on race, religious, caste, community, or language in relations to the elections and classify it as a corrupt electoral practices. Corrupt electoral practices, that is. Is it clear? So Representation of People's Act, Election Commission also has drawn this. Right? Then what are the committees says? What are the committees says about the hate speech? You know, this committee in 2014, this committee which was formed, Borough Committee, this committee proposed amending section 153 of the IPC. So what it says, that promoting or attempting to promote an act of prejudicial to the human dignity which is punishable. That means if they are promoting or attempting to promote prejudicial to the human dignity, then they should be punished for 5 years. 5 years and fine or both, as well as section 509 of the IPC. 509 of the IPC, the word, gesture, or an act intended to insult a member of particular race which is punishable by 3 years. If a person, see, it is written 509 says word, gesture, act, member, particular race which is punishable for 3 years. So this committee recommended for this amendment to section 153C and 509A. Then TK Vishwanathan committee also recommended to include section 153C and 505A of intendment to commit an offense on the basis of religious, race, caste or community, gender, gender identity, sexual orientation, residence, place of birth, language, disabilities or tribes. It proposed a sentence of up to 2 years imprisonment and fine up to 5,000. Okay, these are the committee's recommendations, right? Then if you look at what are the cases which are there. Then, sir, we have the policies regarding, regarding the hate, to deal the hate speeches with regard to the social media? The answer is somewhat yes, somewhat no. See, there is no particular definition for the hate speech. That is a major drawback. So what happens here? See, the law commission, before going to these cases, let us see this law commission. Law commission also proposed that there should be the 267th report. 267 law commission report. A report recommended to include two sections. One is section 153C, what are the committee recommendations, and the section 505A. So this section 153 was drafted to cover an offense committed when any person uses threatening words which are intended to cause fear, or comments hatred for the purpose of including violence through words spoken or written, visible representations or signs, etc. So we have seen the identity. Then also 505, what the 505A includes provision of penalizing causing fear, provocations or violence, provocations of violence. See, even the 189th report, 189th report of the parliamentary standing committee parliamentary standing committee on home affairs in 2015 recommended the incorporations of separate and specific provisions regarding with the Information Technology Act to deal with the online hate-related speeches. But none of these recommendations has been acted upon, and this partly given rise to ambiguity in constructing hate speech by the various constitutional courts. So the need for the hour to specialized legislation that will govern the hate speech to propagate via internet and especially social media is necessary also. So recommendations were not concluded. Is it clear? Recommendations were not considered here. But this, even what are the laws that are dealing, what are the cases you see? That Arup Bhuvan versus state of Assam. Okay, Arup Bhuvan versus state of Assam. So they also said that there should be dealing with Arup Bhuvan versus state of state of Assam. See, what this is, the court that is mere act cannot be punished unless the individual resorts to violence or incites any other persons to violence. This is a court says. But Rangarajan and others versus Jagjeevan Ram. In Jagjeevan, the court decided in this case that freedom of expression cannot be suppressed unless the situation created by the dangerous. Okay, freedom of speech cannot be suppressed unless there is a situation that is creating danger to the communal violence in the public interest, and threats should not be remote. Okay, there should be a close and direct link with the expressions in the questions. And even the Pravasi Ballai Sangathan versus Union of India, we have seen that the efforts to marginalize individual based on their membership in the group, other to seek delegitimate in that group members in the eyes of majority, reducing them in the social standings, etc. That the High Court of Karnataka in the campaign against the hate speech was opinion that the hate speech versus the state of Karnataka 2020 was the opinion that Indian Penal Code illegalizes the speeches that is intended to promote anonymity or prejudice, maintenance of harmony between the classes. Okay, between the classes. So it is an illegalizing. The IPC is illegalizing the hate speeches, anonymity. Even the state of Karnataka versus Praveen Bhai Tagodia. In this case also, what the government, what the court says, they emphasize the need to sustain communal harmony to ensure the welfare of the people. Communal harmony. Okay, even in the Amish Devang versus Union of India, Amish Devang versus Union of India, the Supreme Court held that hate speeches has no redeeming or legitimate purpose other than hatred towards the particular group. Okay, so they said no, the hate speeches has no redeeming or legitimate purpose other than hatred towards particular group it is. Okay, even so these are the cases which are there, right, for the welfare. Then for the hate speech of the Karnataka also said that IPC illegalizes this, that is intended to promote the anonymity. So the state of Karnataka versus Praveen Tagodia welfare. Here it talks about the emphasis to sustain communal harmony to ensure welfare of the people. Okay, then why we need to regulate this hate speech? You see, mainly to create social dividend. Why we need to regulate is to create the social divide and threat to the peaceful coexistence. Like individual believes in the stereotypes in their minds. This let believe that their class, their group are inferior. So they cannot have, because of this, they cannot have the same rights. So there is a social divide that creates social divide because of hate speeches. And also there is a stubbornness to stick to particular ideology for that reason. Okay, so mainly what are the issues which are facing in the hate speeches? See, lack of selective enforcement. Number one, communal harmonies are increasing, communal riots are increasing. Number one, selective enforcement, lack of effective execution, and whatever we are dealing, they are old provisions. So subjects like what we have to read in the way forward, subjects like hate speeches becomes complex issues in dealing with countries like India, which is very diverse, and it is very difficult to differentiate between the free and hate speech. And there are many factors that should be considered while restraining speeches, like strong opinions, offensive comments towards certain communities that affect the dignity, liberty, and equality. So alternative forms of settlements also we should go. We all have to work together and communicate efficiently for our country to be a healthy place to live in. And for particularly social media, if you see, the reference can be drawn to the Australian federal law. There is an Australian federal law that is dealing the Criminal Code of Amendment Act 2019, which impose liability upon the internet service providers, like what we have in the IT intermediaries guideline, guidelines 2020, IT intermediary guidelines 2021. This is so in the same way we should also, so which imposes the liability if such persons are aware they're using the violent material, then it is defined to include material that a reasonable man would regard offensive and accessible through the service provided by them. So there should be specific, see what is the conclusion we can make, that it is thus taking the international situation, international standard, it is important for specific and durable legislature provisions that combat hate speech, particularly the propaganda online and through the social media. And for this, we need to enact and amend IPC, Information Technology Act. Ultimately, this would be possible only when the hate speech is recognized and reasonable restrictions on free speeches. Okay, so these are the things. So thank you, one and all.